Members of the jury,
before you hear the evidence in this case, I'm going to spend a few minutes explaining some basic principles that will be important for you to deciding this case. I also wish to explain a little further what I expect will happen during the course of this trial. I shall begin with some general comments on the judge and jury system. This system is one of the oldest and most important to our legal traditions. It is a team system where you are the judges of the facts, and I are the judge of the law. Each of you has been selected for this trial as a judge of this court with responsibility over facts of this case. Just as when I was appointed to undertook my duties, I was sworn into office. You have taken an oath before impact on your task as a jury on this case. You are, for this trial, judges of this court with the exclusive responsibility for assessing and reaching conclusions concerning the evidence. By the same token, when I tell you what the law is, my view of the law must prevail. I am the exclusive judge of the law with exclusive responsibility for this trial. It will be wrong for you to decide this case on the basis of what you think the law is or what you think it should be. There are two other basic principles which are fundamental to your role as jurors. They are the requirement for proof beyond reasonable doubt and the presumption of innocence. The requirement for proof beyond reasonable doubt means just what it says. No person in Canada can be found guilty unless the Crown proves each and every part or element of the offence beyond a reasonable doubt. Similarly, our system of law requires the accused person be presumed or consumed to be innocent. Brian David Patterson has no obligation to prove that he is not guilty or to explain the evidence by the Crown. The law presumes to be innocent until you, as a trial of fact, decide otherwise. What does this mean to you as jurors? First, it means that the law requires you to decide whether the accused is guilty or not guilty, based on a careful consideration of all of the evidence that you'll hear in this courthouse. Second, the requirement for proof beyond a reasonable doubt and the presumption of innocence means that you must pay close attention to the evidence, because you can only return the verdict of guilty if you are satisfied with each element of the offence charged is proved beyond a reasonable doubt. If you are left with a reasonable doubt after you considered all of the evidence, you must give the benefit of the doubt to Brian David Patterson and return a verdict of not guilty. When I finish these remarks, I will call upon Mr. Berger, the lawyer representing the Crown, to make his opening statement to you. Mr. Berger will tell you what he expects the evidence will be and what he expects the Crown witnesses will say. The purpose of this opening statement is to make it easier for you to follow the evidence as the witnesses testify. It is important, indeed, critical, that you understand that the opening statement of the Crown is not evidence, because it is not given under oath by a witness from a witness box. Opening statements are given for a very, very specific reason. The evidence in a trial such as this is not a narrative that unfolds chronologically and sequentially by the book or TV play or movie. Witnesses are called who testify as to what they know about what they know, a series of events. In many respects, it is like a jigsaw puzzle, with witnesses testifying as to a particular area that they know about, so that you can understand the whole picture. The opening given to you is so you can have an overview of the evidence, so that when each piece comes forward, you can fit it into the overall picture easily.
it's very important that you understand
that what is said to you by counsel in opening statement is not evidence. The evidence will come primarily from witnesses who testify from the witness box, and also from documents or exhibits placed before you.
Once Mr.
Berger finishes opening statement, he will call the first Crown witness
and will
begin direct examination of that witness. Direct examination is a series of questions that gives a witness an opportunity to tell you what he or she knows about the case.
On
direct examination, counsel is not supposed to ask questions that suggest the answer, which is known as leading questions. It is considered objectionable because it demounts the counsel given the evidence while the witness meaning agrees or disagrees.
After Mr.
Berger asks all of his questions to the witness,
Mr.
Darrow will have the opportunity to conduct cross-examination of the witness.
Like
direct examination, cross-examination is a series of questions.
The purpose of
cross-examination is to test the evidence given by the witness and to bring out facts of the accused. Counsel may ask questions to test the truthfulness or ability of the witness,
to see
things or remember them,
or he may choose to
ask new questions.
Leading
questions are allowed on cross-examinations.
After the
completion of cross-examination by Mr. Dowell,
the witness
may be by Mr. Berger, and a new matter is brought up during cross-examination that may require further explanation.
This
procedure will continue for each witness until you've heard all of the Crown witnesses.
Once the
Crown finishes presenting its evidence,
Mr.
Darrow may present evidence on behalf of his client.
If
defense chooses to present witnesses, we will follow the same procedure as we did for Crown witnesses. Only this time, Mr. Darrow would conduct direct examination, and Mr. Berger will conduct cross-examination.
Where
an accused person decides to present evidence, the Crown may have the right to call evidence in reply.
If that
If that happens, it will be similar to the first part of the Crown case.